Welcome to our Moot Court on the value of health data. We're really excited that so many people of you are joining us today. For those of you who don't know what a Moot Court is, basically it's a simulated court proceeding. And you already joined one of the parties that you will support then in the later argumentation on winning this case. So basically we're interested in two matters or two broader questions today. The first one is how data providers, usually clinical data providers, shall be rewarded for their contribution to developing AI technology. And the second broader question that we're interested in is if such a technology is developed, how we can ensure that it is used in the public interest, considering that EU citizens have contributed with their data to such developments.
Thank you, Theresa. I will introduce the parties we have for this case. So we have Maria over there with the white jacket. She's the head of legal at Healthy Innovation Hub, which is a Spanish technology company that recently developed a groundbreaking AI application for the diagnosis of brain cancer and sold this AI application for 30 million euros to a US-based company that produces medical devices, mainly for North America. Then we have Daniele here, who is the head of contract cancer unit at Turin Hospital, which provided 1/3 of the data used to develop the AI application to the Healthy Innovation Hub and received 10,000 euros for the data. Last but not least, we have Henne, who is from the non-profit organization Patient Rights in Germany, which participated in the initiative AI for Health, via which patients from 17 member states pooled data on their cancer treatment and grant their data to research in the public interest.
And Clara was so kind to already introduce, of course, their fictional affiliation. Like their real affiliations are here on the slides. You can maybe ask them afterwards. But since we want to do not disturb our fictional court case, we stick to the fictional names and everything. So here we have a quick overview over kind of how the whole thing is structured. We will invite in just a minute each of the parties to give a short introductory statement that they already have prepared on their perspective on the court case, and you will also hear more about what actually the case is about. And after that, we will have a first round of consultation, which means that you within your groups will have the chance to discuss with your speaker the matter and the argumentation, and also discuss how you will respond in the second round of statements to the arguments presented also by the other parties. Then again, we have statements, and afterwards, again, consultation. And the second round of consultation will also include potential negotiations between the parties. So whereas in the first round, you're only talking to your groups, in the second round, you're also allowed to consult with each other. And finally, the final statement, and at the end, we will hear from our honored judge. Looking forward to that. All right, are there questions until this point? Of course, you will have questions about the case, but you will hear more about it in the first round of statements. But anything else about the procedure or... No? All clear? Perfect.
Just to make an additional statement on our fictional court case, for this scenario, the European Health Data Space Regulation has been adopted and entered into force because for those of you who are already familiar with such a regulation, Article 42 would solve our issue of what is a reasonable fee, but for the purpose of this fictional court case, it does not exist. The Article 42 does not exist. And for those of you who are not familiar with the European Health Data Space Regulation, do not worry. What we want to achieve is more global discussion on, as Theresa said, both what is reasonable fee and as well as public interests.
Yeah, with that, we would like to invite Daniela for the first statement. An applause already, maybe? You have 2 minutes. We will watch the time.
So where's the judge?
The judge is over here.
I'm not sure this microphone works.
It's only for recording.
Okay,
actually.
it's only for recording, okay.
All of you only want to record the statements, so you have basically privacy in your groups, but we would like to have the...
So, Your Honor, on behalf of my clinical institution, I'm raising the following complaints. 2 years ago, our institution received a request from a Spanish technology company for the procurement of 1,000 imaging studies, a substantial part of the AI company's needs. So the company informed the institution that the imaging studies would be used to develop artificial intelligence tools for the diagnosis of cancer. At the time, the institutional legal department expressed a positive opinion, considering both existing regulations and the potential importance of the innovation for citizens within the EU boundaries. The institution agreed to provide the data for a reasonable fee, pursuant also the HDS that was determined to be 10,000 euro, which was sufficient to cover the cost for the extraction of the data and for from the local PAC system and for anonymization. Last year, the institution, however, was informed through national media that the company's AI tool had been sold to an American company for 30 million euros. This came to a surprise, considering the small sum that the company had reimbursed to the institution for the development of the AI application. So we contest the amount, considering our substantial contribution, we contest this amount. I can give you the details later if you want. I therefore request that the reimbursement be renegotiated, taking into consideration not only the compensation for the cost, but also a share of the profits generated from the AI innovation. Based on our evaluation, we believe that a compensation of 500,000 euro, equivalent to 1.67 of the earnings for the sale of the AI tool to the American company, would be fair. Nevertheless, we would like to ask you, Your Honor, what is your opinion on what should be a reasonable fee and the criteria to determine such a fee accordingly. Thank you.
Thank you as well very much for the first statement. Next, I would like to invite Aline from Better Tomorrow.
Your Honor, the patients who gave their consent to the data being put to secondary use did so because they wanted to promote the public interest. With the sale of the technology, there is a risk that access to European patients will degrade or even cease. The interests of the patients need to be respected going forward, irrespective of who owns the technology into which the data was originally incorporated. The progress enabled with the data that those patients shared needs to benefit the wider public in Europe. Hence, we demand that access be granted to the algorithms at 2 levels. First, the algorithm in its state of sale should continue to be available to European public institutions on the same terms of use as it was while it was owned by the Health Innovation Hub. These terms include the price and other conditions that determine how users of the algorithm get access to it. Those public healthcare institutions, mainly hospitals, should be able to extend their contracts into the future with free or limited payments, as have occurred in the past. Second, the initial training data enabled complementary innovation. Patients should continue to benefit from the ongoing process that their contribution enabled. The relative importance of the initial data will arguably decline over time, the speed of which will depend on the share that initial data constitutes. We demand that access for European health institutions has to be granted at rates that include a discount compared to North American healthcare institutions. That discount must amount to at least 100 minus 10 times the number of years passed from the moment of sale, ending therefore after 10 years. By getting access to the long-term progress enabled with their contribution, patients can be confident that the contributed data continues to serve the public interest. Thank you.
Thank you, Aline, as well. So last but not least, the defendant. We have Maria from the Healthy Innovation Hub. Here you go.
Your Honor, I am Maria and I represent the defendant in this case, a technology company. We ask this court to dismiss all the claims raised by both the clinical data provider and the data altruism organization, the patient's representative group. We believe the clinical data provider was duly compensated under the European health data space, which clearly states that data holders should be allowed to charge a fee for making data available. We support this. We believe that the quality and quantity of data utilized in the development of a cutting-edge technology plays a crucial role. However, the European health data space wants to encourage the sharing of data for secondary use. It does not want to encourage obtaining windfall profits for data providers. We believe the concept of reasonable fees refers to compensating the costs incurred by the data providers for making the data available. It should not reflect a share of the profits generated by the innovation, by the AI application. Regarding the claim brought by the Data Altruism Organization, we shall reference the Data Governance Act, under which European legislators have established healthcare as an objective of general interest, for which the altruistic transfer of data wants to be encouraged with no boundaries. Well, there is no doubt that the AI application developed by the defendant is of general interest. Allow me, Your Honor, to say that the cancer diagnosis tool developed is an incredible societal breakthrough. The application improves cancer diagnosis accuracy and health outcomes. And the fact that it has been sold to a non-European company does not hinder its general interest purpose. It just reflects the value of the technology and underscores the importance of incentivizing innovation within healthcare. Your Honor, we urge this court to consider the long-term implications of this case, to ensure that the benefits of this technological innovation are accessible to all those who need it globally, to not let narrow self-interest threaten the progress made in cancer management, and to protect the rights of innovative companies that invest in developing products that benefit society. Thank you.
All right. Huge thanks to each party to present their initial statements. You now will have 12 minutes in your groups to discuss the first statement and develop a second statement.
Okay, thank you. So, it's been hard work, but Your Honor, I really would like to further clarify my request. At the moment the institution signed a data permit with company, we were asked to provide data, okay? We understood that the data would be automatically retrieved from the archive of the hospital by company software. And we also were aware of the fact that the company would provide anonymization software. This would be, we knew that this way our work would be limited mainly to the IT personnel, not doctors. When then further requests arise from the company, we had to prepare a scientific protocol. It had to be approved by the ethical committee. We had to get our legal expert involved, and moreover, after we started collecting data, the company found out that the data was not really perfect. It was heterogeneous. And so we had to look through all the quality of the data, and we also had to perform segmentation, which means we had to contour the lesions, okay? So all in all, the project was far more time-consuming than expected, and there was one important point also, that the institution was involved in publications, in peer-reviewed journals, which means that the institution was involved scientifically. So the institution rightly requests a small share of the intellectual property. Moreover, must be added that considering the value of youth citizen life, which is 6.1 million euro, 10,000 euros seems a very small sum. And furthermore, I must add that the company lacked transparency on the size of the company business. That was a bit of a surprise when we found out that the software tool was sold for 30 million euro. So I'm finished.
All right, thank you. Thank you very much. So we're looking forward to hear from yeah? So from Brendan. Is it okay if we record? Yeah, okay, perfect. Here's your microphone.
Fake microphone. Okay.
Oh, thank you. Yeah, 2 to 3 minutes.
2 to 3 minutes. Excellent. You're going to have to bear with me because I'm going to have to go with my own legal system in addressing the court. Should it please the court, I'm Brendan Ambrose. I'm acting on behalf of the Public Institute. To restate our claim, we are looking for access to the algorithm and we are looking for a discounted rate to the tool should it be licensed to the European Union. Our argument stands on, if not but for the European data, the tool and the algorithm would not have been what it was. It would not have been created. We represent the patients, and in that they have a right, an inherent right in the data which they gave over to the hospital. Now, we are arguing here that the doctrine of exhaustion of rights does not apply, and combining that with the purpose limitation in which this data was handed over to the hospital, the golden thread that attaches to that data does not flow through all the way through to an American company to which the algorithm was subsequently sold. With that, we believe it is eminently fair and reasonable to say that there should be some form of discount or license through to a European Public Benefit Institute and access to that data to do further analysis in a European context. I'll pause there for any questions from the court. Sorry, we come from a very formal legal system. In that, I then deplore you to please consider the patient's rights and that golden thread which I have mentioned before, that the patients were not fully and totally aware in what they were handing over, and that right which still attaches to their data, which was pivotal in creating the algorithm itself. Thank you.
Thank you very much. So now I would invite, please, Maria again. Yeah, thank you. We're curious about your second statement. Mm-hmm.
Your Honor, the claim brought by the data provider, the clinic, does not take into account all the risks and all the funding compromised by the AI company. The profit made by the AI company is irrelevant to the data provider's claim. The price reflects the overall value of the application, not the value of the data. The contribution of the data provider was just limited to providing and making available the data. And, Your Honor, we believe we should draw your attention towards the many factors that contribute to the true value of any AI application. Of course, the quality of the algorithm and the user interface are essential, as is a well-planned marketing strategy, pre-processing of the data, effective customer support, or for instance, seamless integration of the platform. All these elements work together to ensure that the AI application delivers optimal results and provides maximum value to the users. It is crucial to note that the claimant, the data provider, the clinic, incurred no risks or costs in the development of the AI application, and now they want a share of the profit. Its involvement was limited to providing data. In exchange for their contribution, they were duly compensated, and their role in developing the cancer management tool was concluded. It seems that the clinic is attempting to profit unjustly from our hard work, in addition to going against the principles of contract law by trying to renegotiate now the agreement. This is not only, in our opinion, unethical, but it goes against the very spirit of the European health data space. Your Honor, regarding the concept of data altruism, which is defined under the Data Governance Act, data subjects, such as the patients that the data altruism organization is representing, can voluntarily make their data available in an altruistic manner, meaning that they shall not seek or receive any reward beyond the compensation of the costs of making data available. Of course, this applies for patients, for data subjects, and for data holders, such as the clinic. The concept of public interest does not vary according to how strongly an innovation benefits EU patients. If the innovation satisfies an objective of general interest, which it does not contradict the idea of altruism.
Thank you very much to all the parties for their second statement. And now, new rule for the next round of consultation. You can actually consult with the other parties and maybe try to negotiate a compromise. You have 15 minutes to do so. May the ruling be in your favor. Thank you very much. Time is up. It's time now for the final statement before the ruling of our honored judge. I will ask the clinical group to start with the final statements, followed by patient representative, and of course, like in a real court, defendants have the last word.
So thank you. So, Your Honor, we are aware that, of course, and we respect the work of the company. And the company has told us that they have to develop software interface, they have to validate, and lots of activities. Okay, but we're just asking to the company a fair compensation for the work of the institution. We're not asking more. We're asking about 1%, 1.6% more. We're not asking. The compensation that we will receive from the company will serve for investments. It will also allow more patients to be treated, and it will support further innovation. So we think that it is fair. So consider that the institution also has some risk, because if, let's say, some patient comes back to us and complains about inappropriate use of his data, who's going to take the responsibility? Is it going to be the company or the institution? It's going to be the institution, okay? So the company is also worried about, discouraged that it will be companies, AI companies will be discouraged through Europe from investing in the development of AI applications because of this money going to institutions like ours. But company must remember that without data, they will not be able to develop any tool. Moreover, AI software must be updated and will require more data in the future. So keeping good relations with data provider is a very important, okay? Not only for development tool, but also for optimization. So I'm just going to close saying that it's not within the scope of this trial, but we just simply wonder as an institution whether the patient data that we provided the company has been sold to the USA together with the software. This is all.
Thank you.
Thank you for patient rights representative.
Okay, should it please the court? So we've looked at a few things in this matter, and it really boils down to a massive risk towards the European public, which is the lack of fair access for European citizens to a potentially life-saving algorithm. Now, my learned colleague would say that there is a public benefit in the fact that this is now available in the United States of America. And while, with all respect to the United States of America and their healthcare system, it is a for-profit healthcare system. And by selling an algorithm which could potentially save lives of European citizens to an American company, you land up in a situation that might result in an exorbitant fee being charged to European citizens for this technology. As a result, we reiterate our claim, being that we have access to that algorithm, and that if licensed to the European Union, it is licensed at a fair fee commensurate with similar technologies within the European Union. That's me.
Thank you very much. Then, last but not least, I would like to invite Maria again. We are curious to hear.
Your Honor, it is with great confidence that I stand before you today to affirm the satisfaction of the clinical provider with the fees paid up until the news that the application was sold to a non-European company. Not once did they raise any concerns regarding the fees charged to the defendant, and thus no dispute resolution process was ever initiated under the Data Act in order to determine more reasonable terms. This, Your Honor, we believe speaks to the seamless and efficient functioning of the transaction back then. Now, suppose the application has been developed, it's highly skilled to diagnose a rare or difficult to detect type of cancer that disproportionately affects EU patients. The US company that has purchased the AI solution will, quite likely, seek to license it back to hospitals and clinics in the European Union. This would allow for widespread access to the AI application and its accurate diagnosis, and therefore it will improve patients' outcomes. Would the patient organization consider this public interest? That's our question. Your Honor, if the claims brought by the claimants are to be accepted, it would set a precedent that would discourage AI companies throughout Europe from investing in the development of AI applications based on health data, and this will undermine the progress made so far. Thank you.
Thank you to all the parties for the statements and really interesting arguments. I will now give the floor to our honored judge for the ruling.
Easy. So, ladies and gentlemen, so having regard to the written procedures and after considering the highly brilliant observation submitted by the parties, the court wants to highlight the following points. First, the court needs to stress the absence of clarity of the parties' intention in the agreements, which is most damaging because before and among the EHDS rules that we are trying to interpret and construe today, it is most important that for this kind of project, the agreements of the party should be very clear on whether or not it is the compensation is due for the cost or for profit sharing, and the court cannot stress enough the necessity of securing this beforehand. After saying this, since in the absence of clarity of the agreements regarding the notion of reasonable fees due to the hospital, the court sees that there is a need to qualify and differentiate the notion of the composition of the cost and the share of the profit. And in view of the statement of the party, the court considers that there is clearly unexpected costs that have been incurred by the hospital that were not initially provided for in the agreement. The hospital stated especially that they were initially not supposed to do the extractions and to assist in the provision of the data, which was supposed to be automatically collected by the tech company. So there is a risk of the cost being derisory or paltry, and of the contractor being void on this matter under civil law. That being said, the question is also about whether or not the company should have provided a share of the profit given the substantial part of the data that was used in order to train the AI that was ultimately sold to the US company. In addition, the question is also about the existence, of course, of a public interest at the beginning of the project, of course, and regarding whether or not AI training can be considered as presenting a public interest. On that, the court notes that the criteria of public interest under EU law, especially, for instance, under French law, where is there many case law on this, consider that development and research benefiting to patients, whether a large number or a small number, but regarding, for instance, a rare disease, may qualify as presenting a public interest, whether or not the company is from the EU or not, and that one of the main criteria is the publication of the results and the fair access to the result of the research and the AI training. That being said, public interest is a criteria that is used for further use of the data and not for the further use of the technology, which does not automatically enclose the data. When you train an algorithm, it does not enclose the data. We may need some further clarification on whether the data was sold along with the company, but this, of course, is another point. In addition, the court agrees that for a medical device, there is probably no legal ways of forcing the marketing of a technology within a market, especially when you need regulatory authorizations. And so this restricts the court's possibilities as to the marketing of the technology within the EU. On the third point, regarding the access to the algorithm, the court notes that at the initial state or the enhanced state, there is a constraint linked to the existence of intellectual property rights on the source code of the algorithm, and if not, there is also trade secret that could prevent to a request from the parties to publish the code. In addition, the public interest, however, in this criteria of publication of the result strongly recommends to provide some kind of an access to the result of the research which may cover the documentation of the source code more than the papers that were initially published, as being said by the parties, after the project. So, on those grounds, the court hereby rules that the public interest of the initial processing of the data training cannot be challenged under the EHDS and DGA, whether regarding the initial training or the sale of the algorithm. The sale of the algorithm is not subject to public interest. However, in order for the condition to the public interest to be complete, there is a need to order a publication of the result and of the documentation of the algorithm so that the community of the patient can benefit from the innovation that was provided by the training of this AI. In addition, for the duration of the voluntary marketing of the product within the EU by the tech company, the agreements in place should be maintained on the negotiated terms that have been provided by the parties. But if the company decides to stop or not to continue and to freely terminate the agreements in place with the EU hospitals, the hospital shall be provided with the right of option to purchase the right on the technology, and especially the IP right on the source code and the documentation within a price taking into account the initial contribution through the data, which could be construed as a discount assigned by the parties regarding the price of the technology. Third, on the main question of whether or not the notion of reasonable fees must be limited to cost, the court considers that given the new facts provided by the party, the cost of the technology must be re-evaluated in order to be fair, since 10,000 euros, given the number of patients covered and the cost incurred by the hospitals after the conclusion of the agreement, makes it derisory and paltry. However, regarding the question on whether or not there must be a profit sharing included in this compensation, given the need for an efficient and quick decision on this, the court has decided to refer to a preliminary ruling to the European Court of Justice in order to, in order to ensure a quick resolution of the case.
All right, thank you everybody very much for, sorry, 5 more minutes, just a quick, I think first of course thank you to all the participants, to all the experts joining us. We just wanted to mention, maybe now that we're back in the real world, where this discussion is coming from. Most of the experts are also part of the ProCAncer-I project, a Horizon 2020 project that also Clara and I are working on. And in particular, this discussion about how to reward data providers is at the moment ongoing in this project, and I'm sure it will be ongoing also on a European level. And yeah.
Thank you. And to unusually close this workshop, first of all, thank you so much to make this fictitious court case come to life. And we're going to introduce the real identities of the speakers that you joined. We have Maria, who is working for Quibim, a Spanish company, and who is also working for in our project ProCAncer-I. We have Daniele from the University of Torino and Cardiolo Cancer Institute, also working on ProCAncer-I on one of our clinical partners. And then we have 2 additional speakers that we are very happy that joined us today. Aline Blankets, working for Wikimedia in Germany, and Lorraine Meunier-Baucher, a lawyer at McDermott, Will & Emery in Paris. And to introduce ourselves, Theresa Henne, who is a research associate and a PhD candidate at the University of Vienna in the Department of Innovation and Digitalisation in Law, and my dear colleague on ProCAncer-I. And I'm Clara Saillant, also working in the same department, not PhD candidate, working among other projects in ProCAncer-I. Thank you very much for everyone for attending, and also please do not hesitate to share feedback on this Moot Court format in case we would have the opportunity of maybe doing another round next year. And thank you very much for your involvement.